Selamat datang di era di mana privasi adalah hak yang tidak dapat dikompromikan. Dengan mengikuti Undang-Undang Pelindungan Data Pribadi, Privasimu mempersembahkan Privasi Management Tools pertama di Indonesia, sebuah kreasi dari anak bangsa. Privasimu juga menghadirkan end-to-end solution, mulai dari persiapan, konsultasi, hingga implementasi kepatuhan pelindungan data pribadi pada instansi dan perusahaan. Lindungi data konsumen Anda, lindungi bisnis Anda dengan Privasimu.
Oke, selamat sore Sobat Mahir semuanya. Selamat datang di acara live class kita hari ini. Dan acara live class kita hari ini lumayan unik nih, karena kita hari ini mungkin teman-teman udah lihat, yang bisa dibilang lagi lumayan hot nih akhir-akhir ini, karena dengan adanya isu pencurian data dan lain-lain, ini menjadi concern dan bukan hanya di Indonesia, ini juga jadi concern dari berbagai negara, di antaranya ada dari Singapura, ada dari Filipina, dan juga ada dari Indonesia. Nah, hari ini kita bakal bilingual nih teman-teman. Kita bakal pakai bahasa Inggris dan juga pakai bahasa Indonesia. Sambil teman-teman juga kita belajar bahasa Inggris bareng-bareng dari speaker-speaker kita yang keren hari ini. So, in this digital era, data privacy protections has become crucial issue in the worldwide, including Southeast Asia itself, including countries like Indonesia, Singapore, Malaysia, Philippines, and each have their own regulation to govern, protect. Have Personal Data Protection Act or PDPA. Malaysia also have Personal Data Protection Act, Protections Act or PDPA, and Philippines with Data Privacy Act of 2012. So, with all of us is facing a new unique challenge of the implementations of the protections data law. And this event is titled Privacy Compliance in Indonesia, Singapore, Malaysia, and the Philippines about projections and challenges. And this aims to explore the latest development and challenges in data privacy compliance across the region by bringing together the stakeholder from both public and private sector. This event we will be discussing in talk show terms about the difference and similarities in privacy regulations as the strategies for addressing cross-border regulatory change. And we'll be going into our first agenda. We'll be hearing an opening speech from Mr. Eric. So for Mr. Eric, the stage is yours.
Yeah. Okay. Thank you, Mas Jonathan. Yeah. Sorry. I think I have a noisy background because I did not find a good test yet. But yeah, I think this test will be on our speakers. Yeah, our esteemed speaker. There is Prof. Abu Bakar Munir. Yeah. From Prof. Abu. Yeah. Since I joined the also Pico Girona from Philippines and Chuheji from Singapore. So I think this interesting because Indonesia is a bit late for the regulation. So as we know that as per my previous experience, yeah. So before there is PDP regulation in Indonesia, I learned much from Singapore, Malaysia, and Philippines. Yeah, especially Philippines and Singapore because PDP Singapore has a lot of good publication. Same as the Philippines, yeah. So I learned much about the templating, yeah. Either when we do ROPA, DPIA, and etc. So I think here we are, yeah. 2022 we have PDP law enacted, and this year will be effectively enforced, yeah, for all of the clauses in our PDP law. So I think this is a good discussion, yeah. So we can learn from different perspective, yeah, how our neighbor, yeah, Singapore, Malaysia, Philippines, they are more experienced in PDP before us. So I think we hope that we will have a full discussion from the experts regarding the different perspective of PDP regulation. So hopefully this can be our additional reference in the future while waiting for the government regulation, our data protection supervisor, so we can learn from these countries. And if there are any PDP implementation initiative that required certain information that in Indonesia there is no such information. I think we can learn from Singapore, Malaysia, and Philippines. So I think this is for the speakers. I think that's all from me, Mas Jonathan. Thank you. I will be back to you. Yeah. Hope
Okay.
you are enjoying the webinar. Okay. Thank you.
Okay, thank you, Mr. Eric, for the opening speech. The next agenda will be hearing opening speech from the CEO of Pijar.
Thank you, Pak Erik, Prof. Abu Bakar Munir. Thank you, Bu Indriaswati Diah Saptaningrum, PhD. Thank you, Pak Mifiko Gorona Piodos, and Pak Johiji, PhD. Thank you for all of you being willing as speakers to share about privacy compliance in this live class. First, let me introduce about Pijar. Pijar is platform Indonesia Belajar, or in English, Indonesian Learning Platform. Pijar is an education online service that provides one-stop education platform, including vocational education, aimed to enhance public awareness regarding the rapid advancement of technology in Indonesia. Pijar as a platform have built together and create collaboration to strengthen the digital transformation in Indonesia. Based on a report from BSSN as National Cyber and Crypto Agency, in 2022, a cyber attack in Indonesia increased 22% compared to the previous year. This cyber attack consists of phishing, malware, ransomware, and up to DDoS attacks. The Indonesia government has taken various steps to improve cybersecurity in Indonesia, and it's been stated in Indonesia law and regulation, especially in Indonesia cyber law and implementation of electronic system and transaction. In order to support the government, Pijar created a special training and development program as the result of collaboration with Telkom Indonesia, including data protection, IT risk management, law security, and policy, and so on. This training and development program is one of our serious action in educating the public, and we hope this program will help us to understand the importance of cybersecurity in our daily digital behavior. To achieve our shared objective and future goals in this direction, it is important that we join hands and leverage on the complementaries and synergies between Southeast Asia countries to a much faster and higher growth trajectories. So everybody, let's enjoy this live class. I hope we can get some benefit from this live class. Thank you very much.
Thank you, Mr. Jufri Ardian, as the CEO of Pijar Indonesia. For the next event, the next agenda, without any further ado, I'll be passing the torch to our fellow moderators. There's Miss Clara Tobing. Hello, Miss Clara.
Hello, Mas Jonathan. Good afternoon.
Good afternoon. How are you?
Very fine, very excited to have our live class today.
Okay, so you're ready for the talk show?
Of course.
Okay, so please go ahead. The stage is yours.
Thank you, Mas Jonathan. Good afternoon, ladies and gentlemen. My name is Clara, and I will be your moderator for today. Once again, welcome to our live class, Privacy Compliance in Indonesia, Singapore, Malaysia, and Philippines, Projection and Challenges. Joining us on today's live class, three experts from Indonesia, Singapore, and Philippines are very ready to share their knowledge with us. Before we begin our live class, allow me to introduce them one by one. From Singapore, Dr. Hee Ji Jo, Deputy Director of Singapore Institute of Technology. Dr. Jo specializes in the impact of media on the family, cyber wellness, and cybercrime, and he has presented academic papers on parental mediation and video gaming. Dr. Joe currently serves as a member of the Media Literacy Council and Films Consultative Panel. He is a deputy director at SIT Training and Learning Academy, looking into nurturing the applied learning and competency-based education practice. Welcome, Mr. Joe. Hello, already waving to our guest today. Thank you for joining us today, Mr. Joe. Next, we also have from Indonesia, Dr. Indria Swati Diah Saptaningrum, lectures of Atma Jaya Catholic University, Indonesia. Dr. Indri has extensive experience in the nonprofit sector for over 15 years. Her areas of expertise including human rights and information and communication technology, Indonesian law, and also legal reform. She is a senior researcher at ELSAM and previously served as the executive director of ELSAM from 2010 to 2015. She is also worked as a freelance researcher at Indonesian Associations of Lawyers for Justice or APIC, and also a legal staff member at Indonesian Corruption Watch, and as the research and development coordinator at the Realino Study Center, Yogyakarta. Welcome and thank you for joining us today, Dr. Indriawati. Okay, thank you. Last but not least, from the Philippines, we also have Dr. Vico Gerona Piados, lawyer and professor of law in the Philippines. Vico Gerona Piados is a lawyer and law professor based in Davao, Philippines. Currently, he teaches at St. John Paul II College of Davao, while also practice as an attorney at Almasa Filarente Alpas Law from May to December 2023. Previously, he is contributed as a legal researcher for the Sangguniang Panlungsok ng Davao and Espejo and Yang Espejo Law Office. Fico holds a Doctor of Law degree from Cor Jesu College and degree in Political Science and Government from the Ateneo de Davao University. Welcome and thank you for joining us today, Dr. Fico.
Thank you very much.
Thank you. So, okay, without further ado, I welcome Dr. Fico first to joining our live class for today. Hello, Dr. Fico.
Hello, good afternoon.
Good
Mabuhay.
afternoon. Mabuhay. How are you today, Dr. Fico?
I'm fine. I'm really fine. It's 4:16 here in the Philippines.
4:16.
And I also speak in behalf of the Philippines when I say that we are thankful that we are given the platform for us to show our own version of the Privacy Act. Thank you very much.
You. Thank you very much. We also honored to have you today in our live class for today. So, okay. For our guest today, maybe for a little bit background, Philippines right now have the Data Privacy Act or DPA of 2012, which aim to protect personal information in both of the public and private sectors. The regulations also align with international standards like GDPR, which emphasizing transparency, consent, accountability in data protections and processing activities in the Philippines. Moreover, Philippines also has National Privacy Commission or NPC, which was established to enforce the DPA and oversee data privacy practices. So these commissions actually provides the guidelines and conducts investigations to ensure compliance, promoting awareness and education on data privacy rights among the citizens of Philippines. So Dr. Fico, for opening our live class today, I want to maybe ask your insight. In your opinion, how effective are the current privacy laws in the Philippines in protecting the consumer data in Philippines, Dr. Fico, please?
Miss Cara, I have a presentation
I
also.
have
I have a presentation, and I do believe that the questions, the 5 questions that presented in the panel of the created, can be answered by my presentation. Just a little bit.
Very good. Very good. Please, you can start, Dr. Fico.
Share my screen. Good afternoon, everyone. From the Philippines, mabuhay. Now, the internet can be an overwhelming effect now. With technologies changing all the time, no matter how safe you are to try to be, sooner or later, you may find yourself unfortunate to get hacked. Now, the sooner you detect something bad has happened, the faster you respond, the more can minimize the impact. Now, the question is, have you been hacked? That is the primary question. Speaking of the Philippines, now the Philippines has growing and an important business process, management and health information industry, total to IT spending of pegged at 20 billion US dollars in 2022 and expected to grow more than 10% of it, or reaching to 33.9 billion in 2027. Now, it is driven by the substantial increase in both private and heightened need for the enhanced digital services, establishment of cloud data center and development of software, and transformation of local government units to smart cities. Now, the Philippines has an enterprise ICT regulatory highlights. Now, it was increased because of the free Wi-Fi for all. The goal, what we call ambition natin in 2040, making Philippines as one of the leading ICT centers in the Southeast Asia, and the Philippine Development Plan. Now, the Philippine government and also outside of the borders. Now, one which I emphasizing today is the Cybercrime Prevention Act of 2012. Now, this is what we call the DPA in the Philippines, or Republic Act 10173. This is an act protecting individual personal information, communication systems in the government and the private sector. Now, the scope of data privacy is very broad. But before we time, now it started with European Union's Data Protection Directive of 1995 up until the DPA's rules and regulation in 2016. Now, in the Philippines, we have conflicting misconception on because when we say privacy, what kind of privacy? Now, if we talk about constitutional right to privacy, it is the right to be left alone. Now, if we say data privacy, it is the right to keep personal information private, which we are zeroing in now in my presentation. Now, data privacy protects persons against authorized and unnecessary processing of information. Now, as it will be shown in my slides later, there are crimes involved, there are crimes which are caused by the breaches of data privacy. Now, it is the policy of the state to protect the fundamental human right of privacy of communication while ensuring the free flow of information. Now, organizations are becoming mindful of the importance of enforcing the privacy policies to safeguard the personal information. Now, according to Hyman and Kovacic in 2019, the awareness led to the increase of privacy legislations in many countries. And of course, because of the Data Privacy Act, which also covers businesses here in the Philippines, it now increases the deal to comply with Data Privacy Act. Now, In the Philippines, we have personal information. Personal information, we define it as refers to the information, whether recorded in a material form, from which the identity of an individual is apparent and can reasonably be directed and ascertained. Now, why do we have? The question is, why do we give importance to the personal information? Until the coming of internet and taking over of internet in our let's say how do you call that, popular, the keeping of the personal information was not really that popular in the Philippines until internet came. Now, because personal information can be singly used or collective ascertained, no? And it can specify recipients. Also, it can be used to proliferate crimes. Now, what are the scopes and application of the DPA? Now, individuals, legal entities that process personal information with some exceptions. Now, if you can see on the definition of Section 4 of the Data Privacy Act, it is very broad. That's why in the Philippines, we don't have a separate law covering natural persons and juridical persons. We cover all. DPA is that the DPA law or the Data Privacy Act has an extraterritorial application, meaning it can pass through boundaries and borders. And the act further applies the processing of personal information of the Philippines, regardless Philippine citizens, regardless whether they are where they reside. Now, these are the list of those persons who are not covered, or some instances that is not covered by the DPA. Employee, title of business, classification of salary. That's why the fact that the government is an official, the person is a government official is not can be divulged. The title of the business, the title, the business address, and the office of the individual, the classification of the salary, the name of the individual on a document prepared in the course of employment, information of the individual who was performing the service contract under the government. Essentially, it relates to government. Information necessary to banks and other institutions under the jurisdiction of our central bank, the Bangko Sentral, and the personal information originally collected from residents of foreign jurisdictions in accordance with the laws of the foreign jurisdictions. That's why when I handled the case last time, that's why the birth certificate issued by the foreign jurisdiction or the foreign country is not really that protected here. It's as if we can read it. Now, what is the approach of the DPA, the Data Privacy Act? The three cardinal rules is transparency, legitimate purpose, and proportionality. Now, what are the rights of the subjects? Now, they have the right to information, right to object, right to access, right to correct, right to erase, damages, data portability, and file complaint. Now, processing refers to the operation and set of operation upon personal data, including but not limited to the collection, recording, organization, storage, and updating, etc., and retrieval of personal data. Now, I will show it to you later. Why is it very important and highlighted? Now, data sharing refers to the disclosure or transfer to a third party of the data. And personal data breach refers to the breach of the leading to accidental or unlawful destruction or alteration of the unauthorized disclosure. Now, who is a data subject? A data subject is a person, an individual whose sensitive, personal, and privileged information is processed. In the Philippines, there are 3 classified information: personal, sensitive, and DPA, in accordance with the Data Privacy Act. Now, who is a personal information controller? This is the person that controls, instructs the collection, the holding, the processing of the personal information. And who is a PIP? This is the outsourcee. How about the data protection officer? He is accountable for ensuring that the PIC and the PIP's compliance with the privacy regulations. And who is a COP, a compliance officer? He is ensuring that the compliance of the PIP and departments, units, and the branches. Now, how do you collect personal data? According to the law, it must be declared, it must be specified, and it must be for legitimate purpose. So this is the process of the data collection under the law. There is a collection, there is the use, and there is a storage and retention, sharing, and at the end line is disposal. Now, data processing and consent. Consent is required prior to the collection of all data. The data subject must be informed of the extent of the purpose, and it must be automated for the automated processing of his personal data and sharing information with affiliates, even mother, and it must be freely given, specified, and informed. Now, consent is not required if the following will be the subject of the data collection. Number 1 is the protection of vital interests and to respond to a national emergency and for legitimate purpose of the data controller. So here is the summary of the prior consent. It must be freely given, it must be specific, it must be informed, and it must be indicated and evidenced. Now, the law requires that when sharing the data, the sharing be covered by an agreement that provides adequate safeguards and the rights. It is also subject to the review of the National Data Commission. Now, what is a sensitive personal information? Now, if personal information refers to the personal data, the date of birth, the height, the weight, sensitive refers to the information about individual's race, his health, and education, and it is issued by the government agencies peculiar to an individual, such as social security number or health card number. Now, sensitive information, there must be a consent, there must be pursuant to a law, and that does not require consent and necessity to protect life in person. Now, the question is, why do we need to protect those things? Because in the Philippines, there are a lot of things that there are a lot of crimes that has been attributed because of data breach. So, here are the top 5. Number 1, online threat. So one example is you can use the identity of another to threaten somebody. Number 2, identity theft. So in identity theft, you can use the identity of another so that you can ask for money and everything. And in online scam, you can use the identity of another to let other invest on something. And online libel, using the identity of another to malign somebody else. And also the Anti-Photo and Video Voyeurism Act. Now, the unauthorized processing, these are the crimes, the accessing the information, the improper disposal, the processing, unauthorized access to intentional breach, concealment, malicious disclosure, and unauthorized disclosure. Now, these are the crimes which can be violated. So, the fine ranging from and an imprisonment of 1 to 7 years. So these are the crimes. Now, this is a very opportune time, and I'm so happy because last June 5, 2024, the National Privacy Commission finally issued a strict guidelines with regard corporations. Now, what did the NPC Circular 2022-04 change? The course of data privacy in the Philippines. Now, if you can see, there is already a mandatory registration of companies that employs at least 250 employees. Or if not, they process sensitive personal information of at least 1,000 individuals. And personal information will likely pose a risk, processes, and would likely pose a risk and rights and freedom. And other businesses that do not meet should still submit a declaration undertaking exemption. Now, what's the effect of this? If you check the first three, they are obliged. They are obliged to register themselves to the National Privacy Commission. But the kulatilia, or let's say the whereas clause, other businesses do not meet, still submits for a declaration. Now, what happens to that? You are still being monitored by the National Privacy Commission if you submit a declaration. Now, it gives strength to the law and it gives protection to the consumers. Also, trafficking will be halted. Crimes such as libel, online scam will be halted because of this. Now, as to cross-border privacy, I already discussed there is a cross-border or extraterritorial application. One attribute of that is because of the APEC, the Asia Pacific Economic Cooperation, the cross-border privacy rules, to which the Philippines is a signatory. Now, while it is a voluntary, the Philippines is very active on the accountability-based system that facilitates privacy-respecting data flows among the APEC economies. Now, on February 2016, Information Integrity Solutions released an APEC Commission report to join the CB assessment of possible benefits to economies and businesses joining to CBR, the CBPR. Now, how can the APEC CBPR system help your business? Now, because of its cooperation, it bridges differing national privacy laws and reducing the barriers, now promoting your business to adherence to the enforceable standards of the best. Now, what are the challenges? The challenges is that still in the Philippines, there is still a lack of awareness, lack of the right of people to focus on the matters, and programs relative to the mostly on low priority. Now, the creation of a privacy program is now on the watch. It requires an entity involved in data processing to review the procedures in obtaining the consent, limiting to the process defined for the purpose of data privacy. So here are my references. And I am ready for interpellation. Thank you very much.
Thank you very much, Dr. Vico. What a very insightful presentation. So we know that Philippines is ready for free Wi-Fi, right? So ambition nothing. And also, Philippines made a huge cooperation with white shareholders in the Philippines. Okay. While Dr. Fico already explained us about a DPA presentation, but I still have one questions for Dr. Fico.
Yes.
In your opinion, Dr. Fico, because Philippines made the regulation in 2012, so it already evolved in the realm of data privacy. In your opinion, what can be improved or adding into the current DPA to strengthen the regulation of the privacy data in Philippines, Dr. Fico?
In my humble submission, the Philippines must use or must really let us say in a good way abuse the CBRPS, the cooperation between the APEC economies, because as we already know, that's why one of the problems of some jurisdictions is because the laws are only applicable in that territory. Now, in the rise of internet, it is very transnational. It's cross-border. Now, if we exhaust the cooperation between countries, not only in APEC but also in other countries across Asia or outside Asia, we can prevent the crimes such as identity theft, the hacking. We must strengthen the cooperation. The law is really relatively young, if we could say, because it's just 2012. But with the advent of the cooperation in 2016 between the APEC, it really strengthened the law, and now it really fasten the it makes the process faster, and it's because cooperation, the culprits can be apprehended, and also because of that cooperation, investors will be made sure that their investments or businesses will be secured.
All right. So about the cooperation with the foreign countries maybe needed to be adding in the future. Okay. My last question for you, Dr. Fico. You said that one of the challenges in Philippines actually the lack of awareness of the people, right? Since you are also the lawyer, you shared that you also taking some cases on the privacy data, needing of the privacy data, since in the Philippines, the highest crime is actually identity theft based on your presentation. Okay, can you please share how to improve the awareness of the people in the Philippines? Please, thank you.
In my experience and in my research, the cause of identity theft is really the loosened let us say security in our social media. In the advent of social media, the hackers now become very confident because they have the tools to hack an account, and because they can hack the account, in the Philippines your account, then you ask for money from your mother. Your account, then you ask for money from your mother, from your kin. That's already it's already a lot. So now in my humble submission, I just came from the court. I'm wearing my typical court attire because I had a court appearance a while ago. The problem really is that use social media as an avenue for awareness. That is the question. That is really my humble submission, because, for example, in this day and age of social media, especially in the Philippines, almost all of the toddlers, from toddlers to senior citizens, have access to the internet. They have gadgets. So why not use the social media as an avenue for information dissemination? I'm not saying that the old traditional ways of the, no one ever thought of this day that coming, that we can make our symposium or our talk like this on a Zoom. So if we can use this for our conversations, why not we use also this as a way or a tool for us to disseminate information about the data privacy situation in the Philippines.
All right, so it is very interesting. So the tool of the crime should be used as the tool of awareness as well, right?
Yes.
Okay, thank you very much, Dr. Fico, for very insightful presentation and explanations. So I hope that we will meet you in another meeting or another live classes. And for all the attendees or the guests, if you have any question, you can type on your YouTube chat, please. Okay, next I want to move to our next speaker for today, which is Dr. Joe, Dr. Joe Hiji from the Singapore Institute of Technology. Hello, good afternoon, Dr. G.
Good afternoon. Hi.
Hi, how are you?
I'm fine, thank you.
Very fine, thank you. Okay, so Dr. G, we know that Singapore also have the data privacy on the Personal Data Protection Act, PDPA of 2012 as well. And I believe that you already prepared again your presentation. Please, Dr. G.
Okay, so firstly, I want to say a really big thank you to the organizers for inviting me to speak, and who has, I think, wonderfully laid the foundation for data privacy and all that. And thank you so much, because I think it makes my job a little easier. Okay, so yeah, so let me go on to this topic of data privacy and compliance in Singapore. So we're going to talk about ensuring, in a sense, the data privacy and protection in Singapore. The views, let me just go on, just see. Now, so let me go on to PDPA, Personal Data Protection Act. So that's the main data protection law in Singapore that governs the collection, use, and disclosure of personal data in the country. Now, I'm sharing, as the moderator has shared about my experience, I thought I wanted to give you a little bit more background. I also sit in my university's ethics review committee, and that's where I get exposed to PDPA and data privacy issues. Now, so this PDPA actually provides a framework for organizations to manage their personal data in a responsible manner, maybe their clients and all that. The PDPA provides a baseline standard of protection for personal data in Singapore. It complements sector-specific legislative and regulatory frameworks, such as the Banking Act and Insurance Act also, which also covers one part of it. Now, it comprises of various requirements governing the collection, use, disclosure, and care of personal data in Singapore. It also provides for the establishment of what we call a national DNC registry. Individuals may register their Singapore telephone numbers with this particular registry and actually opt out of receiving unwanted, telemarketing messages from organizations. So, for everyone. Yeah. So, let me run through the data protection obligations generally. So in terms of collection of personal data, there are certain obligations involved. One is notifying individuals of the purpose of collecting, using, and disclosing their personal data. And then not just notifying, you're looking at consent as well. Collect, use, or disclose personal data for purposes which individuals have given consent to, also allow them to withdraw their consent with reasonable notice. And then there is a limitation to the purpose. Collect, use, or disclose personal data for purposes with a reasonable person would consider appropriate under given circumstances, and for which the individual has given consented to. So in terms of collection of personal data, these are the obligations involved, the data protection obligations. Now, then there are obligations regards to the care of personal data. So ensure that personal data collected is accurate and complete, especially if it's likely to be used to make decisions that affects that particular individual or to be disclosed to another organization. So accuracy is one of the obligations under the care. Protection as well. You need to make reasonable security arrangements to protect the personal data in your possession to prevent unauthorized access, collection, use, disclosure, or similar risks. Retention limitation. Stop keeping personal data or dispose of it properly when there's no longer needed for any business or legal purpose. Okay. Transfer limitation. Transfer personal data to overseas according to the requirements prescribed under the regulations to ensure that the standard protection is comparable to what we have under PDPA. So in terms of data protection obligations, we have collection of personal data, as mentioned, and care, limitation to the transfer. And then finally, we look at individuals' autonomy over the personal data. So this is part of also the data protection obligations. Now, upon request, provide individuals with access to their personal data and information on how it was used or disclosed within a year, and correct any error or omission where required. Data breach notification. So if there is a data breach, and you know the website that I've given you, you can actually explore it because it also lists down some of the consequences, and later on I'll also go through some of the consequences of violations towards the Act. So if there's a data breach and likely results in significant harm to individuals and or are of significant scale, to notify the PDPC, that's the commission, and affected individuals as soon as practicable. Okay. And then we have data portability. Upon request, transmit the individual's data in your possession or under your control to another organization in autonomy over the personal data, and these are the requirements. So in summary, I felt this particular infographic was very useful to understand broadly the data protection obligations that is housed under the PDPA. Okay. Now, one thing, because in my organization as well as when I interact with other organizations, one thing that is also very important is actually the appointment of a data protection officer. It's mandatory in an organization. All businesses, big or small, need a DPO. Okay. So I think it's no different from what the earlier speaker mentioned also. And this is someone who can develop and implement good policies and practices for handling personal data that meet the organization's needs. Someone who can communicate the policies and practices clearly to employees and customers, and someone who can manage personal data related queries or complaints. So obviously the person aligned to the PDPA considerations, like what I've mentioned just now, the obligations associated with it. Okay. Now, so Data Protection Officer, or DPO for short, basically we're looking at compliance management, responsible for ensuring the organization complies with the requirements of the PDPA and other data protection laws, data protection policies and practices. The DPO is responsible for conducting training, awareness programs on personal data protection policies and practices for employees and other stakeholders. I remember this very vividly because in my organization, we have a DPO as well, who happens to be my friend. And he has been diligently working on training. And in fact, all the staff in my organization have to go for some form of training with regards to data protection, data privacy. Okay. Now, what are the consequences of non-compliance? Well, non-compliance with PDPA can result in significant financial penalties and reputational risks for organizations, affecting their risk we're all familiar with. Like I shared earlier, non-compliance can damage your organization's reputation and erode trust with customers and stakeholders. It is crucial to take privacy compliance seriously and implement effective policies and practices to mitigate this reputational risk. And I thought I share with you all a video, and I thought this video will help explain. The website that I've given you, actually these videos are there. I just chose one that is a sector and different industry. Please feel free to go and browse the video that is there. Yeah. So let me try and get this. I hope you can hear the sound. Yeah.
In order to better safeguard our clients' personal data, I was speaking with Mr. Lam Chi Kin, Group Head of Compliance at DBS Bank and member of the bank's Group Management Committee.
Congratulations for being named the safest bank in Asia 8 years in a row.
Thank you very much.
How do you win their trust?
Being a safe bank implies that we are trusted by our customers. It's something that we continually need to look at ourselves and look at technology as it evolves. So one of the things that we do is we try to automate processes as far as possible. If, for example, there are a lot of paper forms that are lying around, then actually if you lose one of those forms, then chances are that could create a data protection issue. A sonic device that's collecting the information straight through into our processing systems. It kind of builds a paperless environment so that you don't have this prospect of possibly losing those pieces of paper.
What role did the personal data protection policies play to help you achieve it?
Really, honestly, that's about financial performance and so on and so forth, right? But of course, data protection has an element to play in this. A small element, but an important element. And I think it's an element that's going to get more important as they're being trusted with customers' finances, being trusted with customers' investment decisions, but also being trusted with customers' data and the way we use data is very important. The first thing was, of course, the appointment of a data protection officer for Singapore.
Can you share with me the role of a data protection officer?
A DPO has several roles, okay? So one of the most important roles is to come up with the internal framework for the use of data in the way that we comply with the law, but also in the way that we use this data as responsibly as possible.
What were some of the data protection challenges faced by DBS?
Maybe some context first. We're a financial institution. So being a financial institution, protection of customer information is already extremely important. So we came from a framework that already obliges us to take protection of customer information very seriously. Action that existed before the Personal Data Protection Act in Singapore. So if you take these two things that we know already, it's not that much more of a challenge to integrate data protection laws into what we do in real life. Because there are many other countries with data protection laws, we have to make sure that whatever we implement harmonizes correctly. So if you can think about it, DBS has 22,000 employees. You've got to help 22,000 employees to be responsible with data, and it's very, very difficult. So the last point that I would make about the challenge is to try to make whatever we do on data protection for Singapore also harmonize with the way that data protection works in the rest of the world.
Why is data protection so important to you?
Maybe the most fundamental point there is to come back to that idea of trust. We need to be responsible with data, and in some ways that's much, much more important than just complying with the law. It's about being trustworthy for your customers.
So how do you make use of the data that you have?
We know the patterns of withdrawals from our ATMs. So with Chinese New Year, if you know certain ATMs are more heavily used, we put more ATMs temporarily into those locations so that our customers can be served. It's the institution's responsibility thinking about what would the customer want in that type of situation, and then delivering the service or the experience that best conforms with what the customer wants.
Thank you, Chikin.
Fantastic, no
Thank
problem.
you.
Come and see us anytime.
Sure.
Yeah, so I hope you enjoyed the video. Well, in conclusion, privacy compliance is essential for organizations operating in Singapore to protect personal data. And like what you heard, to build trust with your customers and stakeholders. This can be achieved by understanding relevant laws and regulations, complying with requirements, and mitigating the consequences of non-compliance. So this, I thought I'd leave you all with a website that you can actually view for Singapore's brand of data protection.
On your video actually talking about the banking, right? So it takes place in DBS. So can you share to us about how Singaporean company adapting to the stringent data privacy regulations? Because your presentation essentially is about the importance of privacy compliance for organization, right?
Yeah, so I'm okay. So if you're asking how Singaporeans in general, maybe I speak from my point of view, and as well as some of my friends that I know. We are happy that our data is protected. Yeah, so I mean, previously, many years back, I used to get calls from marketeers trying to sell things, and then I'm glad that now they don't call me because I told them, you know, my number is off limits. Please don't pass my number around and things like that. So that definitely I'm benefiting, and I know my friends are benefiting from the data protection that we have here.
All right. So, okay, thank you. So, it shows that Singapore is very the people of Singapore can trust the regulation, right? Because you feel very safe with the new regulation.
I mean, I think the principles of the PDPA is helpful and it protects. But definitely there are breaches. And sometimes, you know, we have to live with those breaches. But I mean, if you're talking about having the PDPA, I think it's really good and useful.
Okay. Oh, okay. Interesting point about the breaches. Since we have 3 countries here, Dr. Fico already told us about the challenges in the Philippines is the lack of awareness in the people in the Philippines. How about Singapore, Dr. G? What do you think the challenges the Singaporean facing in the data protection realm in the Singapore?
Well, if you're talking about challenges faced by, let's say, organizations or companies, I think there are, in the website I gave you, there are certain write-up on it. In fact, there are write-up on non-compliance as well. There are some videos about challenges, like you heard from the video I shared, they also mentioned about challenges. Yeah, so that's one thing. But if you're talking about the consumer clients like myself, I think, like I said, from my point of view, as well as the people my friends that I interact with, we're pretty happy with it.
Okay, thank you, Dr. Joe Hiji. So in a summary, if I can summarize your presentation and video and also our question and answer sessions before. So in Singapore, data privacy governed by the Personal Data Protection Act, PDPA of 2012. So the PDPA established clear rules on how organizations must collect, use, disclose, and also protect personal data in Singapore. Singapore also established a DPO that requires the organizations to obtain consent before collecting any personal data and to take steps to ensure its accuracy and security. So Dr. Joe also already mentioned this blend of protections and flexibility has positioned Singapore as one of the leader in data privacy in Southeast Asia, the balancing the need to protect personal information with demand of the fast-growing digital economy in Southeast Asia. Okay, thank you very much, Dr. Joe Hiji, for joining us on your sessions today.
Okay, thank you so much. I
Thank you.
want to say a big thank you to the organizers too.
Yes, thank you. All right. Next, but last but not least, we also have from Indonesia, Ibu Dr. Indriaswati Dia Saptaningrum, lecturer at the Atma Jaya Catholic University Indonesia. Hello, Ibu.
Hello, good afternoon,
Good afternoon,
uh,
Ibu.
Mbak Clara, and also participant here that joining us from YouTube streaming, if I'm not mistaken.
Yes, by streaming, Ibu. Thank you very much. So, Ibu, we already seeing the perspective from the Philippines and also from the Singapore. But we also know that Indonesia, as Indonesia, we also has enacted our Personal Data Protection Act as well, PDP law in September 2022. A bit late if you want to compare with the Philippines and the Singapore. So this regulation work as legal framework for Indonesia to govern personal data protection in the digital era. So, Ibu, excuse me. So, Ibu, with the newest regulation, as in just in 2022, Ibu, what do you think the current challenges in implementing data privacy compliance in Indonesia? Because the regulation just recently changed here, Ibu.
Okay, thank you so much for inviting me to share my perspective and my take on the recently enacted personal data protection law for Indonesia, which, as you mentioned, have only been enacted since 2020. And as we might be aware that currently we're still waiting for the implementing regulations so as to be able to put the framework into real actions in protecting personal data of the citizens in Indonesia and users in Indonesia. And with that in mind, I think if you ask me about challenges, I think we can learn from other countries' experience around the table, like the Philippines, for example. It took 4 years, if I'm not mistaken, for the commission to be able to fully start functioning effectively and try to again strengthen the protection based on the legal framework provided by law. So in this regard, I think we in Indonesia also might have the same challenges in which we realize that the law provides 2 years transitional period for all institutions that will be subjected by this law to make a preparation for a full enforcement of the law. Yet, as we realize that because the commissions that according to the law will be established as the key institution that will going to oversee the implementations of the law as well as the standard in implementing the protection has yet to be established, waiting for the implementing regulations to be stipulated by the government of Indonesia. So I believe the challenge would be a possible further delay in full enforcement of the legal framework provided by the law. Yet, from my view, this can be positive and negative. In a way, a positive would be if we are a company that is going to be subjected by this law, such delay would actually give more room for us to make sure that we are ready once the full enforcement is in place, that the organization will actually be ready to comply fully with all the standard that will be implemented based on this particular law. So that's one challenges that can also be seen as a good opportunity in preparing, in make a good preparation for the organization and for the company to comply. Another challenges perhaps comes from the fact that uh, we might hear that again and again Indonesia is a targeted country of cyber attack. So the issue of cyber security is really something that is very fundamental, and also as part of a very difficult preparation that I think perhaps that need to be pay attention to by each institution that is going to be subjected by this law. Why? Simply because the issues of aside from trust issue, as the previous speaker also mentioned about this, that the essential issues of why data protection is important is because it contributes to create a trust environment. We also need to be minded that the law also provide some of the requirement that is, I think, relate to the liability of the personal data processing institution to ensure the security of the system, the electronic system in which they provide for the customer. Or yeah, I think the second challenge would be certainly to create a strong, reliable electronic system which is resilient from incidents of cyber attacks, be it from within or from without. From within means this include the weakness coming out from the internal system of the personal of the electronic system of the provider itself. From the outside means that keeping in mind that Indonesia is always becoming a targeted countries for cyber attacks. As already mentioned that there is a trend of increasing incidents over the years about these issues. The third one is certainly related to the awareness as well. I think we experience the same as the Philippines when it comes to awareness of why personal data needed to be protected and why individuals need to contribute on that. Specifically in regard to the digital ecosystem and digital ecosystem industries, this become a problem when it relates to the consumer attitude in which they thought that protecting data will cost me, and because it costs me, I do not want to comply with that. So as you know that the electronic system and digital ecosystem is actually built upon an open architectural system. So in this regard, leaking can come out from a different point of come out from a different center point or node, which in a way can also your consumer and user can also be the point of weakness in your particular overall system if you're a data processing institutions. So I think there is a homework for all of us to actually raising awareness of all individual that each of us is contributing into strengthening as well as weakening the system when it comes to personal data protections. And the idea and the fallacy about, like it's costly and because of that we do not want to do this and that, this actually can be the real serious challenge for us to strengthen the ecosystem and to actually provide us a stronger data protection for users and for individuals. I think that's my take on this issue. Thanks, Miss Clara, on this.
Thank you, Ibu. So, for you see there are three challenges on the implementing our newest regulation, ya Bu. The first is the implementing regulation, which can be the blessing in disguise actually, because we can prepare more into the implementations the regulation. And second, the challenge is actually to make the cyber ecosystem which is resilient to the attack, right? So we need to prepare for our system to be more prepared to overcome the all of that attack. And also, Ibu already told to us that actually the lack of awareness is also a problem in Indonesia because of the consumer attitude that data protection is expensive, right? So with that attitude, the lack of awareness maybe can be a little bit of burden to the implementations of our newest regulations. Okay, so because Ibu already talking about the consumers' attitude in the previous sections, Ibu, what do you think? How can we, as Indonesia, can balancing our needs of data protection with the rapid technological advancement and economic growth, since we use a lot of online shopping, we use a lot of internet banking. So how do you think we can balancing those issue of protecting and also still supporting our economic growth here in Indonesia, Ibu?
Yeah, I think as an emerging market countries, as repeatedly mentioned in different report produced by different institutions, Indonesia even claim to be the powerhouse of digital economy in the futures, with billions of valuations of the digital economic across regions in ASEAN. So with that in mind, I think the really kind of like challenge is how to find the balance between uh, try to promote innovations and uh, fast and high speed digital inclusions of the populations into the digital ecosystem, and be active and as an active individual in the economic, kind of like activities and transactions in the digital ecosystem in one side, but also have an obligations to also protect, considering that we are aware that, as we mentioned before, we have a problem in regard to the lack of awareness at the moment on the level of on the need to have a stringent protection of our own personal data, and the consumer attitude that may actually worsen that situations. So how could we do this? I think the way the country need to navigate and to shape the policy would certainly be, in one side, speeding up the process of enacting the implementation regulation is a must, so that in that sense we can have a good kind of like technical guidelines on how to actually develop a roadmap for providing a stronger and more resilient ecosystem, digital ecosystem, for protecting personal data of user and individual going online. But on the other side, I think there is an obligation for the government as the regulator to also provide an incentive for those who have a commitment already to actually and to be willing to contribute by, kind of like preparing themselves to comply with the standard provided by the law. That's one element that need to be in the policy that's going to be introduced by the government, so that they can be a champion among, different player in the ecosystem. Secondly, there is also a need for the government to provide support for those middle and lower private institutions that actually is going to be subjected by this law, but has less capacity internally to be able to comply and prepare themselves to comply timely when the law is going to be fully enforced by, for example, by October or after the commission is already established by the government. So with these three different elements, I believe Indonesia is going into the right directions, into speeding up the process, yet also without compromising the obligations to help those in need, be it those responsible to protect consumer data as well as the consumer themselves in this digital ecosystem.
All right, Ibu. So very interesting. So actually, you give us the tricks to balancing it by speeding the implementation, obligation to provide incentive, and also supporting middle and lower organizations or who have less capacity to comply with the PDP law. Okay, Ibu. So since on this forum, Indonesia is the youngest to the PDP realm. So based on our, can you give us your opinions? How does Indonesia approach to data privacy if we want to compare to our neighbors in Southeast Asia, Bu? What can we learn from Singapore and Philippines, and what can we implement, and what can we implement into maybe for in our implementation regulations since we don't have it yet, if we want to learn from Singapore and Philippines, Bu?
Okay, I think country across the table provide us with the good benchmark in that sense. For example, once the commission is established, I believe they can learn from the Philippines and the experience of the commission in the Philippines, in which for example, it takes 4 years for them to prepare the institution to be fully functioning and start by a lot of promotional activities, providing handbooks, guidelines for parties that is going to be subjected by the law. And I think that's give us a good example and benchmark on what is to be priorities of the work need to be taken by the commission once there's going to be established. Secondly, aside from that, we cannot have a strong commissions if there hasn't been any full resources to support them to fully functioning as a commissions. We know that there are going to be an independent commissions, and it's already mentioned in the draft of the implementing regulation that is currently at the final stage of stipulations at the presidential office. With that, I think it's a good news for us that finally the institutional design of the commission will be an independent commissions. Yet for that, I believe we need to learn from Singapore, in which the commission is being equipped with adequate resources. So including, in terms of capable staff, professional staff that is contributing and work for the commissions and preparing all the standard and step necessary to help all the subjected parties that is going to be subject of the implementation of the law, enforcement of the law, to be ready and then to start developing a rigorous and solid and reliable measures and procedures to monitor the compliance of each individual and organizations to be subjected by the law. I think there are two at least insight that we can actually learn from them, in a hope that we can actually follow the same path, so that we're going to soon have a strong protection regime for data protection in Indonesia.
Okay, well, very interesting. Maybe for my last questions for you, because I think our time is almost up, but this is my last question. So because you were talking about the resources, and I think it's assumed to say that one of the resources is actually human resources. And that being said, human resources very closely tied to educations. And since Ibu, you are also one of educator, like our previous compliance in Indonesia.
Yeah, I think I'm gonna followed up the view that I mentioned previously about the lack of awareness. And as a lecturer here in the university, I realized that university alone may not be able to do so and to tackle these issues. So independent institution and private institution like Pijar might actually being able to contribute by providing digital content that help to amplifying and to extend the outreach that we need to help to fasten the process of raising awareness of the people. And I think if we can do that and we can encourage the non-academic institution, like higher education institution to also contribute, using the technology as a medium to produce content and educational content like this for specific target in Indonesia, I think we can actually help to solve half of the problems in preparing for full enforcement of the PDP law. That's my take on that. Thank you.
So our live class is actually a means to boost the awareness of the new PDP in Indonesia, right? Bu?
Yeah.
Okay. Thank you very much, Ibu. So to summarize our last discussions on our live class today, Indonesia already enacted the Personal Data Protection Act also in September 2022 as a legal framework governing personal data protection in the digital era. The law includes administrative and criminal sanctions such as fines and imprisonment. Additionally, the PDP law mandates the establishment of an independent supervisory authority to ensure compliance and enforcement. Although it is still a new regulation, the PDP is expected to raise data protection standards in Indonesia, which will provide legal clarity for service providers and strengthen public trust in the management of personal data in the future of Indonesia. That being said, that is the summary of our discussion today. On the behalf of the committee, I want to express my gratitude once again for Dr. Ji Yojo, then also Dr. Indri and also Dr. Fico for joining me in today's discussion. Thank you very much. I hope we will have another time to discuss about this further in the future. Oke, thank you very much. Kembali ke Mas Jonathan, silakan Mas.
Thank you, Miss Clara, Professor Indri, Dr. Fico, for your talk show. I guess everybody had a great experience with this talk show. And ladies and gentlemen, as we come to the end of our event, privacy compliance in Indonesia, Singapore, Malaysia, and the Philippines, projections and challenges, I would like to extend my deepest gratitude to all of our speakers, panelists, and participants. Today's discussions may have not only highlighted the difference and similarities between our regulations landscape, but also emphasized the importance of collaborations and proactive strategies in navigating the challenges of privacy compliance. As we move forward, the knowledge shared here will undoubtedly serve as crucial resource for company and organizations striving to uphold data protection standard while fostering innovation in this rapidly evolving digital era. Let us carry the lessons learned today, and let's continue to work together towards the future where data privacy is respected, protected, and seamlessly integrated into our everyday business practice. Thank you once again for the participants and contributors. We hope we'll leave you here with a deeper understanding and renewed commitment to privacy compliance. Safe travels, and we look forward to seeing you at future events. Goodbye, dan salam berpijar. Thank you.
Thank you and goodbye. See you soon. Thank you very much.
Thank
Bye.
you. Thank you.
Selamat datang di era di mana privasi adalah hak yang tidak dapat dikompromikan. Dengan mengikuti Undang-Undang Pelindungan Data Pribadi, Privasimu mempersembahkan Privasi Management Tools pertama di Indonesia, sebuah kreasi dari anak bangsa. Privasimu juga menghadirkan end-to-end solution, mulai dari persiapan, konsultasi, hingga implementasi kepatuhan pelindungan data pribadi pada instansi dan perusahaan. Lindungi data konsumen Anda, lindungi bisnis Anda dengan Privasimu. Selamat datang di era